rape, in that he sexually penetrated and completed more than once, who was also a child under the age of 12 years. One count of possession of drugs as contemplated in Part 3 of Schedule 2 of the Drugs and Drug Trafficking Act 140 of 1992, and one count of defeating or obstructing the administration of justice. After the conviction of the accused, as stated above, Mr. Albert, who appears on behalf of the accused, requested the adjournment of the matter for purposes of obtaining a psychiatric report and a probation officer's report. Mr. Ngobeni, on behalf of the state, also made a similar request to obtain a victim impact report. The accused is still represented by Mr. Albert from the Pretoria Justice Center, whereas the state is still represented by Ms. Ngobeni from the Director of Public Prosecutions. The accused testified in mitigation of sentence, and his testimony can be summarized as follows. That 3 months before this incident in 2017, he stopped taking his medication as he is diagnosed with bipolar disorder and started using drugs and alcohol. Before the incident, he was constantly for 3 days using drugs to the extent that he could not even go to work. And that gravely upset his fiancée. Despite his fiancée pleading with him to go to work, he did not do so. Instead, his drug dealer came and delivered drugs for him so that he can have further consumption of drugs. On the day of the incident, he left home under the pretext that he was going to work, but he didn't go to work but consumed more drugs and eventually ended up being at Dros restaurant in Silverton. The first thing he did when he arrived there was to run to the bathroom and consume more drugs. Inside Dros, he did not remain where he was initially seated and went to sit outside the restaurant as it was hot inside. He then met a gentleman who was unknown to him at the time called Johan, as he was desperate to talk to any other person. He then consumed alcohol in the company of Johan and in between used drugs. What he can remember is that they end up sitting in the female bathroom, closed the door of the toilet cubicle, and then started consuming drugs. He cannot remember what further happened, and nothing mattered to him, and he was high on drugs. And then he ended up making a mistake. Sober-minded, he could not have done what he did on that day, let alone getting physical with any person. He started using marijuana, also known as daga, when he was 12 years old. His experience with chemical drugs was when he was 13 years old. He used to consume drugs with his mother and described their relationship as that of a brother and a sister, the reason being that his mother was very young when she gave birth to him. His mother introduced him, and that was the beginning of his journey to become a drug addict. When he was 17 years, doing grade 11, he was admitted to the drug rehabilitation center, and at the end of the year, he managed to pass his grade 11, as he had a tutor who was assisting him with his studies. 3 months after his discharge from the rehabilitation center, he was back to drugs, and from there he was in and out of a drug rehabilitation center. He relapsed mainly for the fact that his mother was again back to his life after they were evicted from their home in Cape Town. At that stage, accused was staying with his grandmother. He admitted to taking drugs whilst in prison, awaiting the finalization of this matter, and according to him, it was for approximately 20 times. He felt sorry for his fiancée and his son, who is currently 10 months, and was born while he was in custody for this matter. He regrets that his son will grow without seeing him as his father. He wrote a poem to the complainant, as words cannot describe what he has done and what he is going through. He also penned a letter to the family of the complainant apologizing for his conduct. In cross-examination, it was put to him that he is trying to put blame on drugs and alcohol that he consumed on the day of the incident, and In his answer, he said that when he's sober, he could not have done what he did on that day. The accused was referred to the complainant's JATH, which gives out her length and weight, and was asked why did he prey on such a tiny child, and the accused's response was that he does not know what happened. Ms. Marina Janis, a clinical psychologist, compiled a pre-sentencing report which was admitted into Evidence Exhibit G. In that report, she gave the background of the accused and indicated that accused mother fell pregnant when she was only 15 years. Accused mother and a partner are also on drugs. That the accused was physically and sexually abused when he was still a young child. The accused also attempted to commit suicide on various occasions and was eventually admitted to a psychiatric hospital. Accused passed grade 12 without repeating grades, and whilst in grade 11, he was admitted to Healing Winds Rehabilitation Center for Substance Abuse. Accused was employed at different Vodacom branches during 2017 and 18, and as a salesperson, even though it was not stated in the report as to how much he was earning at the time. He did not personally have friends, but he had several love relationships, with the last relationship being when he was arrested for the current matter. A child who is now 10 months was born of that relationship. Accused started abusing drugs when he was 12 or 13 years old, using cat, cocaine, crystal meth. That led him to be admitted to different drug rehabilitation centers. At Demna Psychiatric Hospital, his stay there was terminated as accused continued to use substance. He promised to kill himself if he is sentenced to life imprisonment. Does not have sexual fantasies towards children, and even though admitting to watching adult pornography, he never watched pornography which involves children. His fiancée informed Ms. Janis that accused after using cat he becomes sexual, but he has never forced himself into her sexual. Ms. Janis found that the accused's childhood circumstances and the child abuse he suffered played a significant role in his development, behavior, and psychological functioning. She further stated that despite his abusive past, she did not find any pedophilic disorder in the accused. The collateral sources also denied the accused ever being sexually attracted to children or watching child pornography. But the fact that the accused chose the child as his victim is a case for concern, and that aspect needs to be closely monitored. The accused is a first offender and does not have a history of perpetrating violent and serious offenses, save for stealing from his grandmother's house to support his drug addiction. The accused is sincerely remorseful based on his interactions with the accused and her clinical observations of the accused, also having insight into his action and its consequences. In cross-examination, when asked whether she regards the accused as a danger to society and that he is not a candidate for rehabilitation, as in the past he was admitted to a rehabilitation centers only to relapse, the response was that if accused can adhere to his psychiatric medication, there is a great possibility that he can be rehabilitated, but there is a great risk of him reoffending if he does not adhere to his psychiatric medication. Ms. Dilith Kelder, a social worker employed by the Gauteng Province Social Development as a probation officer, complied a probation officer's report on behalf of the accused. In terms of the report, the accused was born on the 16th of February 1998, which makes him to be 21 years old. At the time of the commission of the offense, the accused was 20 years old. In a report, she gave the accused version of the offense. In the report, she stated that the accused told her that he put his fingers in the complainant's vagina and realized that it was wrong. He tried to put his penis in her mouth. As he was busy trying doing that, the complainant's mother arrived. Accused does not have previous convictions. Accused is the only child of his parent, and his mother gave birth to him when she was 15 years. His mother is also a drug addict. The accused, as a child, was both physically and sexually abused. Accused grandparents described the accused as a wild child, undisciplined, very much beaten when he was growing up. At the age of 4 years, accused knew that his parents were doing drugs. The accused was eventually adopted by his grandmother, who then raised him as her own child. When accused was 12 years, his mother introduced him to CAT. Accused is currently unemployed and as is in custody awaiting finalization of this matter. She also confirmed what Ms. Janice testified about that the accused has been diagnosed with bipolar disorder. She also confirmed that the accused is still doing drugs in prison. She also found that the accused is sincerely remorseful. She then recommended a life imprisonment sentence to be imposed on the accused. Pauline Kharek is the grandmother of the accused and confirmed that she has been staying with the accused since he was 8 years. The accused has two personalities, when he's on drugs and when he's sober. As a sober person, the accused is a good person who is overprotective, who can take a blame for a thing that he did not do. But on drugs, he's a totally different person from that she raised. She also confirmed that the accused was introduced to drugs by his mother when the accused was only 12 years. And this will happen every time when the accused will visit his mother in Krugersdorp. When the accused was introduced to drugs by his mother, he was together with a friend who were drinking for the whole night, and then the accused mother gave accused care so that she can sober up. There was a stage when accused was free from drugs for a period of approximately an year, and then went back to drugs. Ms. Kharek also confirmed that accused is not a pedophile, and if he could not have stopped his psychiatric medication, he could not have went back to drugs. She conveyed an apology to the family of the complainant and expressed how she is sorry for the accused. Ms. Kharek further testified that the court must not only perceive the accused as a rapist, but it must also consider that there is another side of the accused. After the testimony of Ms. Kharek, the defense closed its case and did not call further witnesses. The state witness in the sentencing process was Ms. Karen Botha, a forensic social worker in the employ of the South African Police, who compiled a victim impact report. Ms. Botha dealt in her report with the trauma the complainant in this matter suffered and the impact of the offense on the complainant. The complainant verbalized to her that she sometimes still sees the accused and she can remember the color of his hair and eyes. And when she sees the accused in her memory, she will have nightmares. She sees the accused every time she goes to bed, and at times she will just try not to imagine the accused and at times she will just try not to imagine the accused and what he did to her, just to try to fall asleep. Her nightmares makes her feel afraid and scared. She's scared that the accused will come to her room like he did in the restaurant bathroom. She remembered the accused told her that when she tells anyone of what happened, he will kill her. She's now scared mostly of men and restaurants. The complainants always conceal her identity because of the publicity this matter has attracted, and she feels that if her identity is made known, she will not be able to attend normal school, but she needs to be homeschooled. The trauma experienced by the complainant is also extended to the complainant's immediate family, and they have put their faith in the justice system. Ms. Botha finally found that the complainant, as a survivor of rape, will have ongoing problems with her self-esteem, social interaction, intimacy, trust, and personal boundaries. She will further, in all likelihood, continue to face emotional, psychological, physical, and psychological difficulties in her life as a result of the rape she experienced. S.S. Tereblanche, in his book, A Guide to Sentencing in South Africa, 3rd edition, at page 151 to page 152, lists the following as general principles of sentencing. 1. The sentencing court has to impose an appropriate sentence based on all the circumstances of the case. The sentence should not be too light or too severe. 2. An appropriate sentence should reflect the severity of the crime, while at the same time giving full consideration of all mitigating and aggravating factors surrounding the person of the offender. 3. An appropriate sentence should have regard to the interest of society. 4. The interest of society and the purpose of sentencing are deterrence, prevention, rehabilitation, and also retribution. Purpose of deterrence is to deter the offender from reoffending and also deterring other would-be offenders. 6. Rehabilitation should be pursued only if sentence actually has the potential to achieve it. 7. Mercy is contained within a balanced and humane approach to consideration of the appropriate punishment. Triad, as explained in the seminal case of State vs. C, consists of the crime, the offender, and the interest of the society. It is a well-known phenomenon that rape is a most degrading type of offense, as it robs its victim their right to privacy and human dignity. It is worst when committed against the most vulnerable in the community, being young children. The complainant was only 7 years when she was violently sexually assaulted by the accused. Apart from being 7 years, she was also a very tiny and small person with a weight of 21 kilogram and a height of 128 centimeters. What was a happy family outing to Dros restaurant became a nightmare for the family of the complainant. Nobody expected that the complainant will be degraded in a manner in which she was degraded by the accused. The complainant was violated at a place where everybody thought that their children are safe. The complainant is now scared of visiting restaurants and she's scared of being in the company of men. The accused violated a child that he was supposed to protect. As his grandmother said, accused is an overprotective person. This incident left the complainant with emotional scars. The incident did not only affect the complainant alone, the family of the complainant was left traumatized because of this rape incident. Ms. Ngobo, who was a childminder at Dros restaurant, had to vacate her employment as she could not cope with what happened to the complainant. She felt that she was a failure as she failed to protect the child she was entrusted with. The mother of the complainant does not wish any parent to experience what she experienced on the day her child was violated. The accused is a very young person who is currently 21 years. When this incident happened, he was 20 years old. At the time, the accused had a fiancée who was pregnant with the accused child, and accused had a good employment as a sales representative. Accused was sexually abused when he was 4 years by a family friend. He started smoking daga at the age of 12. When he was 13 years, his mother introduced him to chemical drugs. That was the start of the journey of accused to drug addiction. Accused since then, he was admitted to psychiatric hospital, drug rehabilitation centers, only to relapse after his discharge from such centers. Accused is content that his child, who is currently 10 months, will grow without a father figure in his life, as he will be doing time in prison. Accused before the incident was on medication, and he stopped taking medication with the sole purpose of returning to drugs. 3 days before the incident, he was constantly using drugs and consuming alcohol in between. On the day of the incident, he also used drugs and alcohol. Accused regrets his action and stated that if it was not for alcohol intake and abuse of substance, he could not have done what he did to the complainant. The accused, from his early life, he lived a broken life, and he appears to me to be a broken person. The person who was supposed to have protected him, guided him, nourished him, introduced him to drugs at an early stage of his life. Gender-based violence in this country is pandemic. The day hardly goes by without the reading in the newspapers or the televisions about women or children being raped and killed. It is unfortunate that the complainant in this matter is a statistic. The annual statistics shows that gender-based violence is on the rise. The government, in its endeavor to curb such rise, is conducting a number of campaigns to educate the communities about the scourge of gender-based violence. Millions of rands are pumped into such campaigns by the government, but it appears that such calls falls into deaf ears. 16 days of activism for no violence against women and children is an annual event which is meant to conscientize the communities about gender-based violence. In the light of the pandemic, the society is putting its hope in the judicial system. Courts must not be shy to impose sentences which will deter would-be offenders of commission of offenses similar to the one accused committed, and also deter the offenders. In the matter of State versus Ntlagaza in another 1997, Volume 1, SACR, page 505, Supreme Court of Appeal at page 518, paragraph E, Harams J.A. stated, the objective of sentencing is not to satisfy public opinion, but to serve public interest. A sentencing policy that caters predominantly or exclusively for public opinion is inherently flawed. It remains the court's duty to impose fearlessly and appropriate and fair sentence, even if the sentence does not satisfy the public. In this context, the approach expressed in State versus Makwanyane and another applies mutatis mutandis. Public opinion may have some relevance of the inquiry, but in itself it is no substitute for the duty vested in the court. The court cannot allow itself to be diverted from its duty to act as an independent arbiter by making choices on the basis that it will find favor with the public. Close quotation. The accused has been convicted of rape with resort under Section 51 in bracket 1 of the Criminal Law Amendment Act, which provides, notwithstanding any other law, but subject to subsection 3 and 6, a regional court or a high court shall sentence a person it has convicted of an offense referred to in Part 1 of Schedule 2 to imprisonment for life. Part 1 of Schedule 2 of rape case, in rape cases refers to 1. Rape when committed in circumstances where the victim was raped more than once, whether by the accused or by any co-perpetrator or accomplice. 2. Where the victim is a girl under the age of 16. Accused was charged with 1 count of rape, even though he sexually penetrated the complainant more than once. It is tried that several sexual penetration following closely on one another should be considered as one charge for the purpose of conviction. But for purpose of sentence, the whole scenario changes and becomes rape more than once, as it was correctly decided in the case of State versus MM 2010, Volume 2, SACR 543 at page 545, paragraph B to C. Section 51 in bracket 3 in bracket A of the same Act provides, if any court referred to in subsection 1 or 2 is satisfied that the substantial and compelling circumstances exist which justify the imposition of a lesser sentence than the sentence prescribed in those subsections, it shall enter the circumstances on the record of the proceeding and must thereupon impose such lesser sentence. The seminal judgment of State versus Malkhas 2001, Volume 1, SACR 469 in bracket SCA guide us how to approach and deal with the concept of substantial and compelling circumstances. However, the definition of what is substantial and compelling is absent in the Act and was deliberately left for the court to develop. Malkhas cautions us not to deviate from the prescribed minimum sentence for flimsy reason. The onus is on the accused to show that there are substantial and compelling circumstances. Mr. Albert, in argument, contended that this court should deviate from imposition of the prescribed minimum sentence for the following reason. 1, that the accused is a first offender. 2, that he is relatively a young person. 3, that the accused is a drug addict, and on the day of the commission of the offense, the accused consumed alcohol and drugs. 4, that the accused has been in custody for 13 months awaiting finalization of this matter. And 5, that he is remorseful. Ms. Ngobeni, on behalf of the state, contended that the accused failed to show the existence of substantial and compelling circumstances. The accused, even though branded as a drug addict, there is evidence that there are instances when the accused can live a life free of drugs. Ms. Janice, in her testimony, said that if accused can adhere to his psychiatric medication, there is a great possibility that the accused can be rehabilitated from drugs. The accused was in the past in drug rehabilitation centers only to relapse, mainly because of the fact he does not keep good company. However, what is disturbing is that despite the accused saying drugs are the source of his current situation, he is currently doing drugs in prison. The concept of rehabilitation, in my opinion, starts with an individual. The accused is not prepared to rehabilitate himself, as he has shown in the past and now. I'm alive to the fact that the accused is a relatively young person. At the time of the commission of the offense, the accused was in a relationship, and his fiancé was expecting a child who was subsequently born when the accused was in custody in this matter. The court, in the matter of State versus Machiji, 2011, Volume 1, SACR 40 at page 47, paragraph 14, stated, turning to the respondent's age, what exactly about the respondent's age tipped the scales in his favor was not elaborated upon by the learned judge. During the course of the judgment, reference was made to the respondent's relative youthfulness without any attempt at defining what exactly that meant in respect of this particular individual. It is tried that a teenager is prima facie to be regarded as immature, and that the youthfulness of an offender will invariably be a mitigating factor, unless it appears that the viciousness of his or her deeds rules out immaturity. Although the exact extent of the mitigation will depend on all the circumstances of the case, in general, a court will not punish an immature young person as severely as it would an adult. It is well established that the younger the offender, the clearer the evidence needs to be about his or her background, education, level of intelligence, and mental capacity, in order to enable the court to determine the level of maturity and therefore moral blameworthiness. Close quotation. The accused raped a very young, defenseless child. When the mother of the complainant was shouting her name, looking for her, accused threatened to kill her if she responds. The accused, after he was caught, he flushed the underwear of the complainant down the toilet. The viciousness in which this offense was committed rules out that accused was immature. All accused testify that the accused is sincerely remorseful. However, both aspects use the words regret and remorse interchangeably, which to me do not connote the same thing. The court in State versus Machiji, in bracket Supra, defined what remorse is when it stated at paragraph 13 that remorse was said to be manifested in him pleading guilty and apologizing through his counsel, in bracket who did so on his behalf from the Dros bracket, to both Ms. KD and Mr. Kennon. It has been held quite correctly that a plea of guilty in the face of an open and shut case against an accused person is a neutral factor. The evidence linking the respondent to the crimes was overwhelming. In addition to stolen items found at the home of his girlfriend, there was DNA evidence linking him to the crime scene, pointing out made by him, and his positive identification at an identification parade. There is moreover a chasm between regret and remorse. Many accused persons might well regret their conduct, But that does not, without more, translate to genuine remorse. Remorse is a gnawing pain of conscience for the plight of another. Thus, genuine contrition can only come from an appreciation and acknowledgement of the extent of one's error. Whether the offender is sincerely remorseful and not simply feeling sorry for himself or herself at having been caught is a factual question. It is to be to the surrounding action of the accused rather than what he says in court that one should rather look. In order for the remorse to be a valid consideration, the penitence must be sincere and the accused must take the court fully into his or her confidence. Until and unless that happens, the genuineness of the contrition alleged to exist cannot be determined. After all, before a court can find that the accused person is genuinely remorseful, it needs to have a proper appreciation of inter alia, what motivated the accused to commit the deed, what has since provoked his or her change of heart, and whether he or she does not have a true appreciation of the consequence of those actions. There is no indication that any of this, all of which was peculiarly within the respondent's knowledge, was explored in this case. Close quotation. The accused wrote a poem to the complainant, a letter to a family asking for forgiveness. The letter and the poem never reached the intended people until the current sentencing process. To me, that is not remorse, but regret, as accused is aware that he is facing the prospect of a lengthy term of imprisonment. It is my considered view that the accused failed to show the existence of substantial and compelling circumstances. Accused pleaded guilty to the charges of possession of drugs and defeating the administration of justice, and I have considered the concurrent running of the sentences. In the absence of the existence of substantial and compelling circumstances, I'm going to sentence the accused in the following. May the accused stand up. Rape, you are sentenced to life imprisonment. Possession of drugs, you are sentenced to 5 years imprisonment. Defeating the administration of justice, you are sentenced to 5 years imprisonment. I order that the sentence in count 3 to run concurrently with the sentence in count 1, which is life imprisonment. Effective sentence is life imprisonment and 5 years imprisonment. The accused in terms of Section 50 of the Sexual Offences and Related Matters Act 32 of 2007, I order that your particulars be included in the register of sexual offenders. Yes. The effect of this order is that in future you cannot be employed in the environment which involves children. That will be your sentence.
All right, well, that's our breaking news story then at this hour. Judge Papi Mosopa handing down a sentence to Nicholas Ninal. And of course, he broke it down in this way. He said that for rape, he gives him life imprisonment. For possession of drugs, 5 years imprisonment. And for defeating the ends of justice, another 5 years. Of course, the judge there saying that these sentences will then run concurrently with that first count, that being life imprisonment. And also adding there, Judge Mosopa, that sex offender, he must be registered on the sex offenders list, which means that in future, in any case, he's getting life imprisonment. But the fact is that he's no longer allowed to be employed or employable by any place that will have children. And of course, we're looking at some visuals still there from the High Court in Pretoria. His grandmother there being comforted, I believe, by a family member as well. You would have heard the grandmother yesterday actually begging and sort of pleading with the court for a lighter sentence, talking about how he was brought up and the circumstances under which he was brought up. He was introduced to Kat by his mother. But of course, the judge not really taking a lot of that into consideration as he gave that life imprisonment, because I saw he balanced out what the little girl has suffered as a result. We've heard about the trauma not only of the little girl, but the mother who has actually left her place of employment as she was too traumatized to continue. The little girl who has nightmares, the 7-year-old that he raped last year, and the fact that she's now afraid to even go to restaurants. She's afraid to sleep. She has nightmares. And of course, the judge taking that into account, and of course that outweighing, as the justice scales would determine, outweighing the issues that were raised by Nicholas and his grandmother about his bad upbringing, and of course what was brought in by the defense in mitigation of a sentence. So life imprisonment there for rape, 5 years for possession of drugs, 5 years for defeating the ends of justice, and those will then run concurrently. The last two will count 2 and 3 will run concurrently, of course, with that of life imprisonment. All right, we're going to cross shortly to our reporter who has been sitting in court for us throughout the day. That's Ofentse Sitimo. He's there for us. He will be outside the court. I understand he's made his way outside the court, so we will be crossing to him shortly. But just some of the things that I think were quite important that the judge did raise. He raised the fact that he felt that the defendant raised the issue of him being remorseful and also expressing regret. And the judge there saying that the two cannot be interchangeable. You must use one or the other. And in fact, going as far as talking about what each means, giving us the definitions there of what regret is, what remorse is. So of course, it seems that the judge was not very much convinced about whether he was regretting and being remorseful at that time. And then the judge, of course, also reminding us that although the accused was sort of found guilty on that one count of rape, there was more than one penetration. And of course, that also affected that sentencing that he put down. So all the issues that he raised there this afternoon had an effect on the ultimate life imprisonment that was handed down. We're going to cross then shortly to Ofentse Sitimo, our reporter. I believe he is there now. A very good afternoon to you, Ofentse. Are you with us? I hope you're at a place where there isn't too much noise. Otherwise, we'll try to get you at a better place. All right, we'll try to get hold of Ofentse again. At the moment, let's cross back to the court. You can see there is some jubilation, some happiness, especially from what I believe are Red Beret supporters. And of course, earlier on, there was a bit of a scuffle outside the court. And in fact, the delayed proceedings between the police and EFF supporters. There was a squabble about that. We're going to get some clarity, of course, from Ofentse Sitimo, who was there to talk to us about what exactly transpired there. But let's take you back into the courtroom and just give you some of those visuals and some of the sound that is coming out of that courtroom in Pretoria. All right, it seems that there is another scuffle or squabble breaking out there between the police and EFF supporters. We're going to get more clarity from Offensive Sedemo, our reporter who is there, about what exactly is the issue and what exactly is happening at this time. We don't know that the earlier squabble, of course, caused a delay in proceedings. And, of course, that breaking news story, of course, just to remind you, as you can see on the screen there, convicted child rapist Nicholas Ninal has been sentenced to life in prison. And, of course, 5 years possession of drugs, defeating the ends of justice, another 5 years, those two run concurrently there. So we're taking you, of course, to those scenes, then Pretoria in the High Court, where there is much happening there. Of course, we saw him being Nicholas Ninal being taken down there to the holding cells, where, of course, he will be taken on to prison there. We know that the scuffle has got something to do with the fact that there was a feeling that Nicholas Ninal would get away with it, but it's strange that there's another scuffle now. So we'll try to understand what exactly the issue at this point is. Now, just a reminder that, the judge did talk about the fact that, it's not about, the sentencing is not about pleasing the public. So just a reminder there, but it does seem that those who are at the court, and of course, from the reactions that I'm seeing on social media, there is some kind of jubilation about the sentence that has been handed down. The judge also referred to precedents, referring to earlier cases, saying that the purpose of sentencing is, of course, to rehabilitate, not to satisfy public opinion. So that was quite an important point, and perhaps many thought that he would give a light sentence after having said that. But of course, we see now that the judge was very firm on where he stood on that issue and where the law, in fact, stands on that issue, adding the effects on the little girl who was violated, and that this sentence should also deter would-be offenders. And talking about the fact that the little girl has many fears now, and he's basically ruined her life. All right, so let's try then to get Offensive Sedemo. He is there for us to talk about what's happening there in court at the moment. I think, of course, we do have the breaking news story. So perhaps the question then to Offensive Sedemo, as we do get hold of him, is what exactly is happening in court at the moment? What is the EFF? What are the EFF members upset about in that courtroom? What are they fighting with the police about? Offensive, good afternoon to you.
Can you repeat the question?
Very good afternoon to you, Offensive. So, we've got the breaking news story, of course, the life imprisonment sentence being handed down. But the question to you right now, there's a lot of scuffle going on in the courtroom there behind you there. And earlier there was some kind of a squabble between the police and EFF members. Can you take us through what's going on and how it delayed proceedings that were meant to start earlier on today?
Well, let me start by saying that Ninal has been sentenced to life imprisonment. He actually failed to win the sympathy of the court to get a lenient sentence. And the scuffle that you're actually talking about was when the EFF members in court were actually chanting some revolutionary songs just before the judge actually came in, as the judge actually delayed. As you remember, we had mentioned that the judge would actually come back to court around 2 p.m. To start with the sentencing procedure, but that wasn't the case. He actually came back just before 3 o'clock, and then they became a bit restless and they were a bit impatient and they started singing, and that's how the scuffle, if you may call it that, actually happened. But joining me now is the NPA spokesperson Phindi Jonondwane. I was actually going to react to the sentence today. Thank you so much, Phindi, for your time. As the NPA, what is your reaction to the sentence today?
Well, we welcome the sentence as the NPA. We believe that the court is justified in handing out a life imprisonment term. That is what we have argued as the NPA, to say, in fact, the version of the accused in that he acted impulsively should be rejected. Evidence has shown that he actually planned this criminality, and therefore should be sentenced in accordance with what the law dictates, which is life imprisonment for rape of a minor.
And I understand that it will be counted as double rape, where he the act that he committed?
Indeed, yes. The accused person was found guilty of 2 counts of rape, one of impeding with the administration of justice, and another one of being in possession of drugs and using drugs. And the court has then delivered 5-year imprisonment terms for the count of impeding with the administration of justice and the one of possession and use of drugs.
And we are almost, I think, a month away from 16 days of activism 16 days of activism against child and women abuse in December. As the NPA, do you believe such periods actually help to deter would-be rapists and would-be abusers?
Well, the nature of the scourge that we are faced with as a country dictates that our courts should come to the realization that society needs more action, society needs more harsher sentences to be imposed against people who commit such crimes. And it also calls upon us as law enforcement authorities like the NPA to continue doing our best, doubling the efforts in ensuring that women and children live to see justice being delivered to them. And so as the NPA, we are encouraged by such sentences. We are encouraged by the fact that at the end of the day, what's the winner here is the interest of justice. Yes, the court always should consider the triad factor, and as the NPA, we have argued that it's not enough for the court to consider only the interest of society, the seriousness of the offense, and the personal circumstances of the offender, but courts needs also to consider the impact of the crime on the child victim and her family. The victim, we have had evidence that she has been left scarred for life, and now to try and as a recourse mechanism to this child is when she sees justice being delivered.
Do you believe this would be a deterrent to would-be abusers, a sentencing, life sentence?
Indeed, yes, we believe that the sentence serves to deter like-minded individuals. Hence we are satisfied as the NPA. The only concerning thing is that no matter how many life sentences our courts delivers, these crimes continue unabated. So we believe that it simply calls for more efforts by government, more efforts by law enforcement authorities in order to nip this in the bud.
Thank you very much. That was Pindile Mjonondwane, the spokesperson of the NPA. But joining me right now is not in my name, my brother. Your reaction to the sentencing, and do you believe it would be a deterrent enough?
Well, we welcome the sentence, and it has really restored our confidence within the judiciary. The thing is that now we need to see more of these sentences start happening. But a big congratulations to the state's team that has actually put forward a good case. It was a clear and cut case anyway in the first place. But for the judge for being brave enough to hand down a life sentence plus 2 5-year sentences for the other crimes that he has committed. And let us remember, this case was about the little girl at the end of the day. And she can finally sleep now, knowing that the monster is not going to come after her again. She can finally look forward to having a life. The family can start looking forward to having a life again. Really in this issue now, we need to forget about him as society. Let us make sure that we build a South Africa that's going to ensure that this girl has got a future, and gender-based violence and crimes as heinous as these are a thing of a past in South Africa. So we really welcome it, and we're thankful for it, and we look for more of those.
So the 10 days of activism against women and children abuse as compared to a sentence like this one, which one is a bigger deterrent to would-be abusers?
Obviously sentences. People need action on the ground. People need to see things happening on a daily basis. We need to see sentences like these happening all the time. And we don't believe in 16 days of activism in the first place. Ours is 365 days a year. As you know, Not In My Name is on the ground on us every every single day, trying to fight and turn this pandemic around that we are facing of gender-based violence in this country. Thank you very much.
We are still in court trying to get some reaction following the sentence of Nicholas Nino to life. As you know, that the other charges include 5 years for defeating the ends of justice, 5 years for, what's the other charge? 5 years for defeating the ends of justice, life for rape, and other acts is also 5 years. And we're going to try to get the EFF to also get a reaction, but it's quite busy and cluttered. But with that, it's back to studio.
All right, thank you very much, Ofensi. While we give you a chance to indeed get hold of a representative of the EFF, we will take a short break. But just to go back to what was being discussed there in the High Court, the NPA spokesperson Pindim Jodondwane welcoming that harsh saying of sentencing, saying that, of course, women and children need to see justice being delivered, and that this is indeed in the interests of justice, because this was a planned crime, as of course we have heard being reiterated throughout. We heard a representative of Not In My Name thanking the judge, in fact, saying that the judge was very brave for giving that life sentence. Also welcoming the sentence there, saying, and I think quite significantly, that the little girl can now sleep knowing that he is behind bars. Of course, we heard the judge was talking about the fact that the young girl had testified and had said that in camera, of course, and had said that she'd been having these nightmares and very scared that this man would come in the very same way that he did at that bathroom on that fateful day at the Dros restaurant in Silverton. So, of course, there, as my colleague Ofense is saying, rape, reiterating again what that sentence is: life imprisonment for rape, 5 years for possession of drugs, and 5 years for defeating the ends of justice. Of course, I believe that the defense had thought that the drug issue might have been a factor that would have helped him in terms of the sentencing, but indeed it seems to have done worse, because the judge indeed spoke about the fact that he had many chances to go to rehab. We heard the family saying, the grandmother saying, that he'd gone to rehab on many occasions and left rehab. He was in and out of rehab, and the judge saying that things like that are a personal thing, and that if you want to change, that indeed you will change. So, of course, the drug issue that his team thought would work for him ended up, in fact, working against him. We're going to cross again to Alfonso Dimi after the short break. I understand he is trying to get hold of EFF representative so that we can get some reaction from them, and of course also clarity about what made them so very angry throughout the day. Let's take a short break. Do stay with us.
We've been all around the country talking to real South Africans about saving money on their car insurance. Let's meet some of them.
My name is Jacques, and I save 403 Rand a month with our insurance. My wife made it happen. I'm a bit of a procrastinator. She nagged me, phone our insurance, get a better quote. I will definitely take her out for a little something special. As a salesman, seeing how insurance does business and the way they treat their customers, I would very much like to take the example and teach that to my salespeople as well.
If you think it's a hassle getting a quote, put us to the test. SMS SAVE to 34473 or call 08600 60,000 to see if you can switch and save. Do it now.
My name is Yvette and I save 1,250 Rand with outsurance. I was downstairs and my husband came down and he told me about outsurance. Then we can pay less than a half. I can't believe it, and I just hugged him and give him a kiss and I said, that's great. I've got that car 5 months now. It feels like when I'm in that car and while I'm busy driving, I don't want to stop, just want to keep on driving.
If you haven't called around for a quote in ages, do it now. SMS SAVE to 34473 and see if you can switch and save.
My name is Rita, and I save 508 Rand per month with insurance. I am a bookkeeper, so I keep a tight rein on my finances. This is going to help me do more of the things that I like to do. Painting, a little bit of wood carving. My car means the world to me. I've had it for 14 years. I feel like $1 million when I'm driving around with it top down. It really makes me feel good.
Real clients, real savings. Don't overpay for car insurance. Put OutSurance to the test today. SMS SAVE to 34473 or call 08600 60,000 to see if you can switch and save.
My name is Bakepi. I saved 918 Rand a month with OutSurance. I couldn't believe the guy. I thought maybe he was just pulling my leg. So I'm a teacher at Karl Malcolm High School in Kokstad. And the lesson I'm giving to you, if you feel you're paying too much, means you are breathing through the wound, contact OutSurance.
If you've been with the same insurer for years and haven't recently put OutSurance to the test, SMS SAVE to 34473 and see if you can switch and save. Do it now.
My name is Pearl and I save 929 Rand a month with OutSurance. I'm an extremely busy person. I run a few businesses. When I need things done, I need it quickly. And that's exactly what OutSurance gave me on my first call. It really made it easy for me. I can definitely use that money to save for a holiday or even save for putting back into my business. I'm going to definitely recommend OutSurance to my clients and make sure all of them switch and save.
Real clients, real savings. They've all saved. Why shouldn't you? SMS SAVE to 34473 and see if you can switch and save. Do it now.
My name is Zanathan, and I'm saving 372 Rand a month with OutSurance. I saw this ad on social media of OutSurance. I replied to it, and I got a call almost immediately. I'm a scientist, and I had so many difficult questions.